Right. Let's see, people are slowly coming in. I'll give people a couple of minutes and then we'll kick off. All right, let's start, I think. So thank everybody for joining us and welcome to another webinar. This and welcoming back Tom Pills to the drone lawyer to speak on more legal topics for drone operators. And really the focus of today is very much on the new privacy laws that are coming out. Most people don't know about them. I certainly didn't know about them until Tom mentioned them. So hoping this is going to, sort of open up a few eyes to what's coming and, more importantly, how to prepare for it. So I think we get the ball rolling. And to start, I guess introduce Tom. Tom, if you want to say a few words about yourself. And oh, sorry, I should probably start by saying who I am. Totally forgot about that. David Cole, co-founder, CEO of FlyFreely. I'll be your host today. And yes, I'd like to welcome Tom to give us a bit of a background on his career. How did he get into this whole thing and what he's typically working on. Tom.
G'day, Dave. G'day, Dave. Thank you very much for hosting, and thank you everyone for joining. Appreciate your time and attention. I've been in law since about 2013, and in the RPAS space since about 2018. Now, I just some recreational flying, and then had developed a professional interest in it, which has then given me the opportunity, fortunately, to work with all sorts of clients, from single pilot operators all the way through to listed companies and government bodies, and also advise both drone-centric organizations or through to organizations where drones are just one aspect of their main operation. So it's been a really fun, interesting journey. And as we all know, the regs have changed a lot in that time. So it's been fun keeping on top of it and trying to keep the industry informed with all these amendments and the related commercial environment in which all the operators are conduct their work.
Awesome. Right. Well, let's, I guess, get straight into the meat of the session. Really talking about the new privacy laws that came into, well, you can go into the legal definitions on how it takes effect and when. But if you want to start, giving maybe an overview of what are the changes and potentially, what's the current status quo and what's changing now. If you want to
Cool,
start
cool.
with that.
So thanks, Dave. There is a lot to unpack. I'm going to keep it very discreet and very focused around RPAS operations. But as for the big picture, before we zoom in, there's this act called the Privacy and Other Legislation Amendment Act. So it's a long name, and that was released on 10 December last year, 2024. And what that did, that created about 100 changes across 10 different pieces of privacy-related legislation, mainly the Privacy Act, but other legislation was affected as well. So ton of changes. It's a big chunky document, and different parts of it kick in at different times. And it's like a patchwork document that tells you where to put different parts into different acts. So very confusing, very patchwork. And I've tried to dig through it and draw out the RPAS related stuff. And it is first important to know that this is not RPAS centric legislation. It is privacy legislation, but we're looking at it, and I'm looking at it through an RPAS lens to see, well, where could RPAS operators potentially be picked up or affected, or how might it affect their operations? Notwithstanding, it doesn't say this is a drone law. This is definitely more the wider context in which drone operators conduct their missions. So of all the amendments, I think there are two real main changes, or two pending changes that we'll consider today. One is there's this civil penalty provision for serious interference with the privacy of an individual. So what that means is the Office of the Australian Information Commissioner, which is the main privacy body in Australia, now has strengthened powers to go after certain organisations for a serious interference with the privacy of an individual. So that's what the offence is, the serious interference with the privacy of an individual. But there are sort of three things to unpack on that. And so an act is an interference if it breaches an Australian privacy principle in relation to personal information about an individual. And the three main concepts here with these provisions where the Information Commissioner can pursue someone, there are three concepts that are really important to unpack. One, it affects primarily only APP entities. Two, relates to personal information. And three, refers to the Australian privacy principles. So they're three sort of hurdles that usually have to be overcome first. And I'll unpack this really briefly because this is unlikely to affect all RPAS operators, but it may. So an APP entity, it's a very long-winded definition in the Privacy Act, but in short, it includes federal government bodies and private organisations with an annual turnover of more than 3 mil. So that's sort of that's the main threshold there. Secondly, it relates to personal information, and what that is under the Privacy Act is it's very broad. It's information or an opinion about an identified individual or an individual who is reasonably identifiable. So pretty much any information that can identify you will fall under personal information. And the third concept is these Australian privacy principles. What they are, they're 13 principles that these APP entities have to consider. They have to consider to manage personal information. So that's the first change, which give the Information Commissioner stronger powers to pursue certain bodies. And like I said, the main sort of threshold is 3 mil turnover, but it also depends on what information you're dealing with as well. And then the second main change, and this second change is not limited to these APP entities. It's pretty much it is open for pretty much any organization. This new right is a right of an individual to sue someone else for a serious invasion of privacy. So for the first time in Australia, an individual now has a statutory right, a right in law to sue an organization for a serious invasion of their privacy. And an individual has a cause of action, can do that against another person if, amongst other things, the person invaded the individual's privacy by, the term they use is intruding upon their seclusion or misusing their information. And intruding upon seclusion includes physically intruding onto their private space or watching, listening, or recording someone's private activities or private affairs. So in the RPAS context, inadvertent capture of someone in a private activity might form one of the grounds for that person to bring an action. It's the times that they kick in are important. So the action for the right for the Information Commissioner to pursue came into play in 10 December 24, but this new right for individuals to sue someone comes into effect in June 2025. And as today's 29th of May, sometime next month, we're expecting this actually to drop.
Awesome. So I might jump in, Tom, and
Yes.
sort of ask a couple of questions. So I've been taking notes because I'm learning as we go. And this might be a bit out of left field. I'm just wondering on so these APP entities are going to have these responsibilities. Can they, even though if they work with a RPAS provider, which is under the 3 million threshold, could they potentially put into their contracts conditions which will essentially transfer some of those responsibilities down to them?
Yeah, good point. So if you're saying if potentially the client is a big client that's an APP entity, and if they contract RPAS work to an RPAS organization that may not be an APP entity,
Yep.
well, there's a specific provision that if it's a Commonwealth contract, not everyone has this, but if it's a Commonwealth contract, that would typically bring someone into the scope of the Information Commission investigations. A Commonwealth
Hmm.
contract will, and that's in the change. But if it's not a Commonwealth contract, it's just a large private organisation, that's a really interesting contractual sort of concept as to how that will be captured. I have to think further about that. So if a APP entity contracts an RPAS organisation who then provides the work, and if they breach, as the action is typically taken against the person breaching, it would be interesting to see, and it's maybe a contractual issue about whether
Mm.
it can be pushed up or pushed down to the other person. That's a really great question. And I think it'd be a matter of
Yeah.
both contracting arrangements, but also whether what the legislation says you cannot contract out of. But that's a really great question, Dave. And I have to take that on notice. I think it's
Yeah, yeah. It just occurred to me.
but if
Because
you've got a big client, it's something for us as operators to be conscious. If you've got a really big client that has a 3 mil turnover or more, that then its chances are they're an APP entity. So you've got to be conscious as to whether you're captured by that. That's a really good question.
yeah, no, excellent. And by the way, everyone, if you want to ask a question, there should be a Q&A function. Yep, there we go. Just got the first one. So great. The other one was around, and I think we may get into this a little bit later. Is there any, you know, capturing audio visual, does intent play into this at all? Like, if you didn't intend to do it, but you still captured them, how does that play out?
Good question. There are some defenses. So as you know, with the aviation legislation, most of that is strict liability, which means intent is not relevant. You think about speeding in your car. It doesn't matter if you didn't know you were speeding, didn't know the speed limit, thought it was different. If you do the act of speeding, you get done for speeding. And most of the RPAS regulations are strict liability. It's about the act. But in respect of this element, obviously Privacy Act, different area of law. There are some defenses, and there is some guidance around that. Uh, with with the element of being able to be sued, one of the elements is that whether the invasion of privacy was intentional or reckless. So if someone's going to try to sue you, one of the considerations is whether it was intentional or reckless. So if it was
Hmm.
inadvertent, that might play or reduce the chances of them being successful, or maybe it's a relevant factor. So you're right, Dave. There is an intent aspect, which is good because 99% of operators, and obviously everyone watching this is usually a professional operator that has no malicious intent, and so any capture is probably likely to be inadvertent. So there is a mitigating factor there if it's inadvertent.
Okay, no, that's great. Great to know. And I don't know if you want to provide any sort of context on, why is this coming about, these sort of changes?
Yeah, so in 2023, there was an entire review of the Privacy Act. And so there's this explanatory memorandum written by the government, the House of Representatives, which is 103 pages. But in short, it said, so these changes which are coming in now arose from this 2023 review of the Privacy Act. And in short, it concluded that comprehensive reform is required to ensure that the Privacy Act remains fit for purpose and capable of addressing the heightened data risks of the digital age. So it's kind of trying to keep up with technology, and it came from this report in 2023, and they finally worked through the system to try to address some of these more digitally based challenges.
Awesome. Uh, so I guess, we're in aviation, we're in drone space. How does this impact, operators' relationship with CASA, if at all?
Yeah, good question. So insofar as, and as I mentioned, the body mainly governing this Privacy Act is the Office of the Australian Information Commissioner. As we know, CASA is about aviation safety, and privacy is typically not in CASA's remit. So I think the only way the way that they could overlap is that if the conduct also breached the civil aviation law. If it's purely a privacy element, then CASA generally is not concerned with privacy. They're more concerned about safety. But you could imagine that some of these things might breach the populist rule or hazardous operation or 30-meter rule potentially. But typically, this is purely related to the Office of the Australian Information Commissioner. So typically not a CASA issue. Um, and so it's a matter of being there's another body, another government body now that you have to be sort of think about in conducting your operations and mission planning.
Yeah, no, great to know. Okay, so I guess we've heard a little bit about what can cause or potentially be a breach. Um, how, what are the mechanisms here that this a breach could, come about, basically?
Yeah, the two main ways uh, that a breach or the two main ways that it may come to an operator's attention is either the first one is people can make complaints through the OAIC website, and if the OAIC saw that and then decided to pursue it, or you provide enough information that you could pursue it, they could then investigate separately themselves to an operator to look at whether the conduct in which they engaged was a breach. So that's putting it to the hands of the government and the OAIC. On the other side, for this new cause of action where someone can sue, it's a matter of someone, establishing a breach and then potentially having, the money and the willpower to actually sue for a serious invasion of privacy. So there's two ways to go about it. Yeah, it's either complaint through AIC or an individual taking it into their own hands, which would be relatively slow and expensive. All court process is relatively slow and expensive, but it is a course of action if someone does feel they were breached and gets some advice and wants to personally pursue someone through the courts.
Okay. And then I guess, if there is a breach to, found, what are the sort of the penalties like? What's that regime
Yeah,
look like?
there's some significant penalties here. I've just got some information on that. So in relation to let's have a look here. In relation to the OAIC investigations, Uh, if the operator is not a company, the fines can be up to $2.5 million. And
Wow.
if it's a company, the fine can be up to $50 million.
Holy moly.
That's
Yep.
huge. But and that's if there's a serious interference in privacy. But if the information commissioner can't get up on a serious interference in privacy, you can get pinged for just garden variety interference in privacy, not serious, and that reduces the to 2,000 penalty units, and it's $330 per unit. So it's a bit less. But you got to think that the way in which I can see this unfolding, because none of this stuff has been tested. All this law is so brand new, you can still smell the paint drying. And the organizations that I can see would be the first likely in the crosshairs of the way I see will be, say, the big social media companies, the big tech companies, those companies that we all give all of our data and information to, and then a matter of how they deal with it. So I can see them being in the crosshairs. So that's why there's huge penalties, because these big social media companies are making billions off our personal information, which most of us willingly give just through interactions. So I can see those type of social media organizations being more of the test case, the more of the typical targets. But nonetheless, RPAS operators are potentially collecting information, are potentially recording things recording personal information because they're recording identifying information, and they're potentially seeing things that you may not otherwise see just by virtue of the altitude issue. So while I don't see RPAS operators being the immediate targets, it's still something very much you should consider in your mission planning.
Okay, cool. So I think, yeah, it's now sort of getting into the what I think is probably the most interesting, what do you do about it? How should you prepare basically and change the way you do things to mitigate this?
Yeah, good point. Well, even if you're not an APP entity, because an APP entity must have a privacy policy, as far as I'm aware on the Privacy Act. But even if you're not an APP entity, it's still worth starting to take the privacy issue seriously, because it's always been an issue. The first thing people ask with RPAS operations is about privacy, and until now, it just hasn't seemed to have had really strong teeth. In my experience, I don't know
Mm,
your experience, Dave. It's an afterthought. It's, yeah, privacy is important enough to do it, but what's going to happen? And most people didn't think too much about that because there wasn't really a cause of action. There hasn't really been a direct cause of action to sue for that. There's trespass and there's nuisance and things like that, but they're a lot more vague than saying, you've invaded my privacy, and now I can go you for it. So that's now become a thing. And so even if your turnover is not more than 3 mil, I recommend that you still should develop a privacy policy if you don't have one, and an RPAS focused one, and another, and then also, so the privacy policy is one document you put on your website or you put with your terms, so it's established how you deal with information, personal information. And then the second aspect I'd recommend is conducting a privacy risk assessment for each mission. So it's this new concept of privacy by design. So rather than conducting the operation and thinking, oh, maybe don't fly over that because that might capture some information not relevant to our mission, but it may still capture something, at mission planning stage, think about the privacy then. Like I said, privacy by design, using privacy as a centric element of your mission planning and looking at that. And that can be assisted by looking at a privacy risk assessment, which is just a bunch of questions just to turn your mind to the privacy issue and say, how can we mitigate our exposure to capturing information that we don't need, or capturing personal information, or capturing persons or other things that aren't related to our mission? And thinking about that right at the start, which can be assisted through this privacy risk assessment. And the other cool resource is the Department of Infrastructure put out that something like don't pry when you fly, I think it's called. I can send this, I can definitely circulate this, but this put out 12 drone privacy principles. And this was written well before the new law, so it doesn't take into account the new Privacy Act, but it's still got 12 interesting principles. And if you generally follow those, it'll help keep you on the correct side of the law insofar as privacy. So I'll definitely recommend looking at that resource. But I've also developed other resources myself and happy to discuss that with anyone who's interested in relation to the privacy risk assessments and stuff.
Yeah, so just thinking from a practical point of view, you think it'd be as simple as when you're doing your, JSA, when you're planning the mission, you would insert a couple extra questions on the privacy aspects. And then if they do raise a potential risk, then record that in as a risk in your risk assessment, and you've added mitigations, et cetera, et cetera.
Yeah, exactly. It's just another element. I know there's a lot of paperwork in mission planning, there's a lot of paperwork and a lot of checks, but I think this is now becoming a relevant one that really ought to be added to those checks just to cover off that element, cover off that risk. Absolutely. But you're right, exactly. Just add that to your normal mission planning.
Excellent. So the other, which I think, and I'm seeing a lot of questions on this, is, going through some examples and working through them just to try and see how it would play out, I think is the most beneficial way of doing this. So we had uh, a preset example here, and I think a lot of the questions people are firing in. This is kind of I think a very similar thing. So I think generally speaking, you're out doing a survey of some sort, whether it's power lines, roads, you're capturing, potentially people's yards, people in their houses. Um, and I guess in this particular case here, we're talking about, the person sees the truck outside with some, logos of the company that's doing the inspection. They see the camera looking at them. Um, and they go, that's capturing me, that's invading my privacy, I'm going to make a complaint. Um, can you, yeah, give some insights into how that might sort of play out?
Yeah, it's tough because you can't stop people or busybodies or even just concerned citizens from making a complaint. But I think at that issue, if they approach, it's all about, as a lot of you are just personable people. And I think a lot of the time, and you would have seen this, Dave, if the operator is just explaining what they're doing and what they're capturing and why they're doing it, a lot of people go from being suspicious to being accepting. Okay, you're capturing that data. And one thing that I've also drafted and thought about is, yes, you've got your privacy policy, which is on your website and tells you how you deal with data. But a discrete version of that, which might help in this instance, is a privacy charter. So it's pretty much just a shortened down, watered down version of a privacy policy that just sort of demonstrates the steps RPAS operators take to address privacy. So if you had a one page of this privacy charter and went, yep, cool, here's what we're capturing, we're conducting this operation. And by the way, we've thought about this, and here's a one pager, here's our privacy charter, which you can look at. And they can see, okay, so you take active steps to ensure you're not capturing information you don't need to, and it's either de-identified or otherwise not used. So even things like that right at the start could help with sort of allaying the fears, and that could then prevent them from going inside. Instead of going, well, I'm going to call the information commissioner, or usually they go, I'm going to call CASA, and then CASA says, well, it's privacy, so don't call us, and then they call the information commissioner. So what might stop that is just have that cordial engagement and give them that privacy charter, and they go, okay, cool, they're actually doing this for a legitimate purpose, which is actually going to help me overall because they're doing something constructive, not prying on me.
And it's probably too early to know this, but do we have any idea how it would play out, right? So say someone says, I don't like that. I'm going to lodge a complaint. They lodge a complaint.
Yep.
What would happen then? Would
Yes.
information commissioner request, documentation or how would that play out?
Yeah, so if the information commissioner finds that it is of interest or does they are, want to reply, they'll often make contact with the operator if they've got that person's supplied your information, yes, your logos on your truck or whatever, and they might make some initial inquiries. And then other things they can issue if it's found something is found to be a breach. There are compliance notices as well. It's not just big massive fines. They can issue compliance notices and other way less harsh penalties. But that's right. It is in the hands of the information commissioner for them to decide, whether they want to pursue it or not. And yeah, they've got a lot of power under which they can make the investigations. And definitely, if you've got something like that, I would recommend reaching out, happy to me or anyone else or any of the other lawyers if you did receive a letter like that, to make sure you do act within your rights and they're not overextending theirs.
And I guess one thing to make clear here, and I'm making some assumptions, that historically, I would assume you would need some sort of physical evidence, i.e., a photo that you could point to and say, that's captured me, therefore you're in breach of my privacy. But correct me if I'm wrong, what the law is now saying is just the fact of the mere presence of that camera is enough to trigger these rules.
Yes,
Is
with that, with with the pending right, it'll kick in June for people to be able to sue for a serious invasion of privacy. An interesting element of that is that invasion of privacy is actionable, so you can bring an action without proof of damage. So usually a huge element of suing someone is I've sustained damages of X amount, business losses, I've hurt myself, something like that. And usually, uh, that you have to establish damage in order to bring a claim. Otherwise, usually it's not worth it, or you get a nominal amount and get kicked out. But with this new cause of action, you can bring it without proving damage. All you have to prove is the element that there was this element that there was, pardon me, I'm making sure I get it right, a serious invasion of privacy, but don't need to necessarily say, therefore I lost X dollars or I had this condition, suffered this condition. It's without proof of damage. So in that sense, it's quite broad. Yeah.
Yeah, I remember when you first told me that, and that's where I was like, wow, okay, this is very broad, and you know the actual evidence of like you being captured is not necessarily required. Like to go, oh, I see that video clip there or that picture there that captured me. It's just merely that it was there and it was pointed in your direction. Um, could give rise.
Yeah, that's right. So there are a few elements. Anyone who wanted to do this would want legal advice to make sure all the elements are ticked off before they bring such an action. But it includes, intruding upon their seclusion, which is this strange new word that the legislation uses. I've never seen the word everyone knows the word secluded, but I've never seen the word seclusion until I read this act. I don't know why they picked a funny word like that, but so you've got to intrude upon the seclusion, or misusing the information, and it was intentional or reckless and was serious. Um, so there are a few hurdles, a criteria that
Okay.
would have to meet before they
Yep.
could successfully sue you, but you can't stop people from bringing actions. But there are some hurdles. You can't just bring it willy-nilly.
Yep. Okay. Well, that's good to know. I guess the other one we had is sort of an example of council worker out doing something that they capture. Again, I don't know if they're, and this would be an interesting question on if it's for surveillance of local laws or it's an inspection. And there's not necessarily a complaint by the public, but the commissioner finds out about it somehow, whether they, watching YouTube videos or I don't know how. They can also then um, initiate some sort of investigation or action. Just yeah, how that would sort of play out, and if that's the way it would play out.
Did you mean an investigation by the commissioner or by the individual? Sorry, Dave, were you thinking?
So on this particular one, it's
Yeah.
kind of the commissioner. So there's
Yeah.
no one said I've been injured. Is that the right term? Damaged. Sorry, that's the word I think. Um, but the commissioner can still take it upon themselves to take some action.
Yeah, as far as I'm aware, that's right. They are empowered. If it comes to their attention one way or another, who knows how, then they do have discretion now to look at that person and potentially and investigate, and then to see where there was breaches as per the legislative requirements. But yeah, they looks like they do have discretion now to conduct those investigations independently of a complaint if it comes to their attention in another way.
Yeah, so I guess it's still to be seen how that would sort of work. But historically, I think we've seen that with CASA in terms of social media and things like that, which they monitor and
Yeah, and
things
I'm
pop
not
up.
sure whether OAIC will take the similar approach that CASA has sometimes when they'll just see a social media post or something like that and then investigate. I'm not sure whether they will also use those means, but that's often how most things are published now. So, and
Yeah,
I'm not sure how aggressive they're going to be with it either. Like I mentioned, I think their crosshairs mainly around using information that we all give through our apps and our social media. I think that's going to be where the focus lies. But if you're an RPAS operator, you still really should adopt that privacy by design approach.
awesome. Right. Well, to I guess finish off the this little section, then we'll dive into questions and answers. So if you've got questions, start getting them in. Um, what's happening? Anything else on the radar from a legal point of view coming this year that we're aware of? I think we're discussing sort of the implications of this in AI.
Yeah,
Uh,
yes. So this Privacy Amendment Act that has all those bits and pieces that has stuff that's happening from December last year. This new cause of action to sue for breach of privacy is kicking off next month, most likely, because it was 6 months from proclamation. So proclamation was around December when the law sort of formalized. So it's going to be around June that happens. Another sort of, I thought, quite interesting element, not necessarily drone centric, but just of general interest, in that by December 2026, so a big grace period, organizations, APP entities that use a computer program to make decisions that would significantly affect individuals' rights need to put in their privacy policy how they do this, pretty much. So, for example, if a Commonwealth organization uses a computer program, which we're thinking AI, to make a decision about whether you're going to get some sort of benefit or not, that has to be in their privacy policy, which is there's two really interesting elements. One is for the consumer, for us, who might be using an organization APP entity, their privacy policy should tell us now how they use computers to affect us or affect a decision they make. And the other element is for these big organizations, they really need to start planning and thinking how to disclose that information so they're not in breach of that requirement to tell people how they use a computer program to affect individuals' rights who interact with them.
Excellent. And I guess, yeah, just sort of wrapping up, sort of where do you think people should focus their energies right now with regards to this whole changing privacy legislation?
Yeah, I think the three main takeaways are one, check that you've got a privacy policy, which you can put on your website. It's just about having it. Two, I would recommend that privacy charter. So it's like a shortened one-pager version of your privacy policy that pulls out the key points. So if you do get that person who makes an inquiry when you're on a site, or if you're in conducting a job somewhere, you can give them this document that demonstrates you do take privacy into account in your operations. And the third thing, thinking about that privacy risk assessment in your mission planning. And I can talk to anyone about that if they want more information, but it's pretty intuitive. But I've been thinking about that for the past year and developed some materials.
Awesome. All right, well, that concludes this section. So let's dive into some Q&A, I guess. So yeah, if you want to get in touch with Tom, his details are there. Feel free to reach out. So let's get into some questions. All right, the first one, Chris, and I guess this is coming back to the application side of things. So if you're broad scale, capturing some broad scale drone imagery and accidentally capture private activity, um, uh, and it's, for example, you're getting someone's backyard, etc., etc. Um, how would, I guess, yeah, would that be fall under this legislation?
Potentially, if there's that seclusion issue, if it's a private activity, but again, if you've just captured it, you'd either just not use when you deliver it to your client, or if you're going to use it, don't use that or remove it or de-identify it, and because it does have to come to someone's attention for an action to be brought. Just doing the act is one thing, but for it to come to the attention of the information commissioner or for someone to know and want to sue you for it, usually that's in the publishing side. So if you're conscious during your operation, go, "Oh, didn't need that bit of data, I caught capture something I don't need," and you destroy it or it doesn't go any further than your internal processes, and it's never published, then the chances of anything happening reduce significantly, obviously.
Yeah, yeah. Because I'd assume any sort of action, that they would request evidence or, what's being stored, and if nothing's there, then nothing's there, right?
Yeah, yeah, and it has to come. It usually needs to come to someone's attention first. Um, yeah.
Cool. I think this was related to our discussion where we're talking about the transfer. Chris was saying that there could be liability waivers in a contract that might kick in. I guess is that was to do with the potentially, I think, transferring of liability
Yeah.
down.
I
Um,
agree. You want to get your contracts tight about indemnifying and also what you can contract out of, and some things you just cannot contract out of. You generally can't contract out of gross negligence, for example. Generally, you just can't, even if the contract says that, you just generally cannot do that. So it's a matter of considering what indemnities or what rights and responsibilities can be passed up and down, and what can't, and just making sure everyone knows what they're responsible for and what their rights and obligations are with a clear
so
contract. Yeah.
yeah, just another question. What does APP stand for?
Yes.
If you just want to, we just reiterate it again and again, I think.
Yeah, no, sorry, I apologize you didn't catch that earlier. Australian privacy principles. So that's what the APPs are, Australian privacy principles, and they're contained in the Privacy Act. And then an organization that's subject to them is called an APP entity, an Australian privacy principles entity.
Okay, that's
Yeah.
not confusing at all.
No. And there are 13 privacy principles, and they're contained in the Privacy Act. And normally your privacy policy usually is centered around those Australian privacy principles. It's just about making sure you just disclosing how you're using data and personal information.
Cool. I think on the previous conversation, Dean was chipping in saying, flying for an emergency service, an emergency disaster, you would fall under the, I think, introvert clause. Maybe that's the, not sure what that one is, or the relevant Emergency Service Act. It would trump some of that. Well, I guess I think the point is, in an emergency situation, some of that privacy stuff gets trumped. Is
Yeah, there are some, and to dig deeper into it all, there are some defenses as well. And some of those defenses do include certain scenarios, which I think do include some of those types of situations. So if you're conducting that type of operation, want to be clear, you could take those defenses into account. But that's sort of a case by case basis, depending whether you're flying for, a state organization or whatnot.
cool. This one from Luke, understands that privacy law prohibits capturing individual identity. Does it also apply to private property images without owner's consent? So
Yeah,
that's the question.
yeah, good
Yeah.
question. So So looking at how personal information is defined, it's a bit of a long definition, but in short, personal information in the Privacy Act is defined about identifying information of a person. So that seems to link pretty much to an individual. So you can be identified. Um, and so if it's just private property and no individuals, then that I'd say is unlikely to fall under personal information because you can't identify a person from that. It's just their property. So I think it'd be hard to bring an action or difficult to have an action against you if there's no individual. It's just a bit of property at a pool or something like that, or your
Mm.
yard without a person there. Because it is all about personal information, which I said is identifying or reasonably identifiable of a person.
Excellent.
Sorry, further point to that, there's other things like trespass and nuisance and things like that. But really, just a side point, interesting point on that. Different states have different provisions. And for example, one concrete example in New South Wales, the Civil Liability Act, which is like a slip and fall act mainly, has this random section, I think section 73 or section 74 of the Civil Liability Act, New South Wales says, words to the effect of, there is no cause of action in trespass by way of an aircraft in its ordinary operations, provided it follows the law. And I think this was written way back. If an A380 goes over your yard, you can't
Yeah.
then sue them to say, "Oh, you trespassed on my property." So it's written in that context. Now we have RPAS, so it's a lot lower. So the reasonability is very different. But a lot of these states do have these carve-outs. If you're following the law and going over someone's yard, there are some carve-outs that you can't sue necessarily for trespass or nuisance if you're following the law and it's a reasonable height. But that's state by state.
That's good to know. So another question, and this may have been answered already. What constitutes an invasion of privacy? Is taking pictures of power poles in someone's backyard considered an invasion of privacy? And
Yeah,
probably coming back to the you've I guess it's the person is the person name.
yeah, it does apply more definitely around the person, because it does talk about a plaintiff and their seclusion. Uh, I'm just having a look what else other resources I've got to sort of answer that more specifically. But it's typically around the person and them having an activity in which they think that it'd be private, considered a private activity. So yeah.
Excellent. Penelope's, I guess, chiming in on the I guess the AI question, which is really interesting. So banks, insurers, actuaries use computers to make decisions that affect people. Do they need to change their privacy policies? And
So with this change around computer reporting on if they use a computer program to make a decision that affects individuals, yeah, that's why it's kicking in December 2026, because it gives a lot of time for these organizations to go, wow, we now have to report. This is my reading of the legislation. I can show you the legislation. I'm happy to provide to anybody to look at the source document. But in short, they've got till December 2026 to work out, okay, we have to report now. Do we use a computer program to affect individuals' rights? And what information do we use to do that? So essentially, yeah, whether Siri or Sarah is denying your job seeker, or whether it's Claude or Craig that's stopping you from your family tax benefit.
but we don't have to worry about that because AI would have taken over by then. So all of this is relevant,
Well,
right?
by December, the rate at which it's going,
Yeah,
by December
exactly.
2026, it's going to be, yeah, everything. AI decides everything now. But no, it's definitely watch this space, and it'd be interesting, a mix of both. The development's very significant, but also trying to develop a privacy policy that will take all that into account, and that's going to be a requirement, and that will be a breach by the APP entities if they don't disclose that.
Excellent. All right, we've got a few last ones. We'll just quickly whiz through. There was a question from Ian around what's the definition of a private act? I think is that referring to Privacy Act or is there a
Oh, as in capturing someone in a private. Yeah, good question. That's a good question around that. There's wording around, I'm just going to find that, but got some wording from the Act
right?
around.
Well, while Tom does that, I'll just go through a couple of other ones. So yes, this question from Buzz. has Tom got some resources? I believe he
Oh,
does.
so
Yep.
about this, oh, sorry, on the seclusion point. So with the right of someone to sue, so not the information commissioner, but the right to sue. So intruding upon seclusion is physically intruding onto their private space, and then the other element is watching, listening, or recording private activities or private affairs. And good question as to what that entails. That usually comes down to the case law as to what constitutes a private activity or private affair and whether someone had a reasonable expectation. And I think from other things I've read, it's whether you've got a reasonable expectation that what you're doing is in private. You know, if you're in your own yard with a fence, for example, I think most people would have a reasonable expectation in their own fenced yard that what they're doing is private and no one else would see it. But you go to it on the beach, you know, very black and white, but do it on the beach, you can't have a reasonable belief that what you're doing is private if you're sunbaking on a beach. So, but that is definitely a case by case decision as to what conduct was captured and then whether that would constitute private. That's a case by case thing. But I can find some cases if someone wants some answers. I can get some examples, drum some examples up. But it's definitely case by case.
Awesome. All right. Well, and yes, last question was around will the recording be available? Yes, we'll make the recording available. So I think we'll wrap up there. Thanks again, Tom. You know, this is like you said, it's all brand new. It's something we generally don't think about too much. Um, so I think some of your points around, you know, some basic mitigations to get in place. So if anything does crop up, you know, you're protected, right?
Yeah, it's just
Um,
about turning your mind to these issues, really. Yeah, yeah.
so yeah, I guess yeah, thanks everybody for coming along. Hopefully that was, you know, half informative and learned something new. And no doubt, yeah, will be ongoing discussion into the year and beyond.
Thank you. Thanks for your time, everyone, and thanks for your attention. Appreciate it.
All right, thanks everybody. See you later.